If I told you the Supreme Court is about to decide whether smoking weed makes you too dangerous to own a gun, you'd probably think I was joking. But that's not a headline from The Onion. That's a real case, and the outcome could redefine what shall not be infringed actually means in this country. Because this isn't about marijuana, it's about how easily the government can decide who's unworthy of rights.
Can people who regularly smoke pot legally own guns? That is what the Supreme Court has to decide, marking the latest firearm case to go before the court ever since its 2022 decision expanding gun rights.
President Donald Trump's administration asked the justices to revive a case against a Texas man charged with a felony because he allegedly had a gun in his home and acknowledged being a regular pot user.
The administration typically defends the right to bear arms, but government attorneys argue that this ban is a justifiable restriction.
The man's attorneys argue the broadly written law puts millions of people at risk of technical violations since at least 20% of Americans have tried pot, according to government health data.
The Justice Department argues the law is valid when used against regular drug users because they pose a serious public safety risk.
Arguments will probably take place in early 2026, with a decision likely by early summer.
So let me get this straight. The same government that lets you buy whiskey by the gallon, prescription by the bottle, and antidepressants like candy is now saying marijuana turns you to a public safety threat. This case, United States v. Hemani, is about a Texas man charged under 18 U.S.C. 922G3 for owning a gun while being what they call an unlawful user of a controlled substance. And I want to quote this verbatim. Hemani's indictment followed a Bureau of Investigation search of his home where agents found a 9mm pistol, about 60 grams of marijuana, and roughly 4.7 grams of cocaine. He had admitted to use of those substances. He moved to dismiss the indictment, arguing that his Second Amendment rights were infringed because the statute failed to define when drug use triggers the firearm prohibition. That right there, failed to define when drug use triggers firearm prohibition, that's the problem. Because laws like this don't protect people, they trap them. They give the government room to decide when your rights suddenly disappear. The Fifth Circuit Court actually got it right when they ruled that 922G3 couldn't be applied to someone who was sober during the firearm possession. Translation: if you're not high while holding the gun, the government doesn't get to pretend you are. But now the Justice Department wants the Supreme Court to bring that law back. And in doing so, they're asking the court to define when freedom ends and judgment begins. Here's the irony. Marijuana is legal, either medically or recreationally, in a lot of states. So we're not talking about outlaws. We're talking about citizens following their state laws who suddenly become federal criminals because Washington refuses to update its definition of reality. And this is where the real danger is. Once the government can strip your rights based on behavioral judgment, they don't stop at marijuana. They'll move to prescription meds, mental health diagnosis, political affiliation, whatever fits the narrative of public safety. Because when public safety becomes the justification, freedom becomes the casualty. The Second Amendment was never about perfect people. If it were, the founders would have disarmed half the taverns in colonial America. They didn't. They didn't say you can bear arms unless you've had too much rum or grow hemp. They understood that rights are a safeguard because people are imperfect, not a reward for being flawless. That's what the government doesn't get. They keep treating freedom like a security clearance, something you can lose if you don't meet their moral standards. And this is exactly why I created the Defend America collection, available at shop.mrcolionnoir.com, because freedom doesn't come with conditions. When you wear Defend America, you're not repping me. You're repping the idea that rights don't need permission slips. The hats, the hoodies, the shirts aren't just merch. They're a message that you either believe in rights for everyone or you don't believe in them at all. So hit the link in the description section of this video and defend your rights while you still can. If the Supreme Court sides with the government, millions of Americans will wake up one decision away from being felons for doing something their state already said was legal. And if they side with the Fifth Circuit, they'll be reaffirming something the founders already knew, that freedom isn't conditional and the government doesn't get to decide when you've had enough of it. This case isn't about weed. It's about whether the Constitution still means what it says when the people in power don't like who's reading it. So yeah, smoke weed, don't smoke weed. That's your choice, but your rights, they're not negotiable. Because once you start letting the government decide who deserves them, it's only a matter of time before you don't. One thing's for certain and two things are for sure. Politicians and tech giants don't want gun content to be recommended to you. And we're all fighting this culture war together. Now, you can help do your part by liking, commenting, subscribing to the channel, but most importantly, sharing this video with at least one person. Together, we can stop the suppression of our 2A rights. And don't forget to click the link in the description section of this video for the products that I mentioned in this video.